And here's why. We have some breaking news. There's a decision from a New York judge in President-elect Donald Trump's immunity case, and that decision means that the case has been delayed by a week. The president-elect was found guilty of 34 counts of falsifying business records in connection with payments made to adult film star Stormy Daniels. Trump denied any wrongdoing. His lawyers are now arguing that the Supreme Court jury's ruling shields him from prosecution. CBS News political reporter, attorney Katrina Kaufman has been tracking the details, and she joins me now. Katrina, so explain what this decision means and whether or not the president's actions that he took in office were official acts. What is the judge considering?
Hi, Vlad. So what we've just learned is we were waiting for a decision from Judge Juan Merchan today on whether or not the verdict in this case should be thrown out on the basis of presidential immunity. What's now happened is this has been postponed by a week. The prosecution has asked for some time to weigh the balance of this jury verdict against the office of the president, the fact that Trump has now been re-elected president.
Hey, everyone. Adam is here. So what just happening, guys? 3 judges. Unanimous. The D.C. Circuit took Trump's single most important legal argument, absolute presidential immunity from criminal prosecution, and dismantled it piece by piece in language so clear there was no spinning it, the line that ended it. For the purpose of this criminal case, former President Trump has become Citizen Trump. Not a uniquely protected figure, not above the law. Citizen Trump, subject to the same courts and the same criminal accountability as everyone else. That was the moment the wall came down.
The U.S. Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay his trial for interfering in the 2020 election. The former president described the decision as a big win. Our North America editor Sarah Smith reports.
The powerful Supreme Court has the final say on what presidents can and cannot do. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties, but they do not have immunity for non-official acts. So what does this mean for the criminal cases against Donald Trump?
Fight for Trump! Fight for Trump!
When he spoke to supporters on January the 6th, was he officially acting as the president or as the losing candidate?
We fight like hell, and if you don't fight like hell, you're not going to have a country anymore.
Donald Trump is facing criminal charges related to the January the 6th riot and attempting to overturn the election results.
Let me walk you through exactly what happened, because this story has layers that most coverage either glosses over or gets completely wrong. The D.C. Circuit ruling was real, it was unanimous, and it was genuinely devastating for Trump's legal position. But the story did not end there. Trump appealed, just as his team said they would the moment the ruling came down. The Supreme Court eventually took the case and issued its own ruling, one that complicated the picture in ways we need to walk through carefully.
U.S. Supreme Court late this morning ruling former President Trump may claim immunity from criminal prosecution for some of the actions he took in the waning days of his presidency. Michael Perchik on it for us. He's following the case and breaking it down for us this afternoon. Michael.
Joe, that Supreme Court ruling recognizing former President Donald Trump's immunity claim for official acts as president, though rejected it for unofficial acts. The majority opinion delivered by Chief Justice John Roberts states while the president is not above the law, that he may not be prosecuted for exercising his core constitutional powers, and he is entitled to at least presumptive prosecution for his official acts. Still, it states that Trump is asserting a far broader immunity than the limited one we have recognized. Now, in the dissent, Justice Sonia Sotomayor countering that it makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law.
Because understanding the full arc of this immunity fight, from the D.C. Circuit's flat rejection to the Supreme Court's more nuanced ruling, is essential to understanding where Trump's legal exposure actually stands right now. The headline captures the genuine panic inside Trump's legal team when the D.C. Circuit ruled.
An appeals court in the nation's capital ruled President Trump can stand trial in connection with charges he plotted to overturn the results of the 2020 election.
Now, the panel struck down Mr. Trump's broad claims of immunity. The D.C. Court of Appeals tossed out former President Trump's claims of immunity from prosecution for his actions while in the White House and leading up to the Capitol riots in 2021. The three-judge panel issued a unanimous ruling, 57 pages long.
But the full story is about what happened next, and why even the Supreme Court's partial pullback did not give Trump the blanket protection he was demanding. The core holding, that a former president is not above the criminal law, survived. And that survival is what matters for everything that comes after. Here is what the D.C. Circuit actually said, and the specific language matters because it is so unusually direct for a federal appellate court. The three-judge panel wrote that for the purpose of this criminal case, former President Trump has become Citizen Trump with all of the defenses of any other criminal defendant. Then they went further. They wrote that any executive immunity that may have protected him while he served as president no longer protects him against prosecution. They rejected all three bases Trump claimed for immunity unanimously, with no dissent, from a panel that included judges appointed by presidents of both parties. And then they wrote the sentence that Trump's lawyers have been most desperate to avoid seeing in a federal court ruling. They wrote, "We cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results." Read that again. We cannot accept a claim of unbounded authority to commit crimes. That is a federal appellate court saying directly, in an official ruling, that the President of the United States does not have the constitutional authority to commit crimes to stay in power. That statement, in that document from that court, is historic. It is the clearest judicial articulation yet that the office of the presidency does not place its occupant above the criminal law. And then the panel went even further and spelled out exactly why Trump's theory of presidential immunity was so dangerous as a constitutional matter. They wrote that his stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Because under his theory, Congress could not legislate, the executive could not prosecute, and the judiciary could not review. That is the court saying, your argument does not just protect you from this specific prosecution. Your argument would make the president completely uncheckable by any branch of government. Congress could not pass laws limiting presidential conduct. Prosecutors could not charge a president for any crime committed in office. Courts could not review presidential decisions. Under Trump's theory, the president would be a king. And the court unanimously said that is not what the Constitution created and not what they were going to endorse. Trump's spokesperson responded by warning that without complete immunity, future presidents would be immediately indicted when they leave office. That tells you everything about how central the immunity argument was to the entire legal strategy. The response to losing it was not a substantive legal counter-argument. It was a prediction of chaos. That is what you say when you have lost the argument and you know it. So what did Trump's legal team actually do in the aftermath of the ruling? They did exactly what they said they would do. They appealed. They went to the Supreme Court. They asked the justices to stay the case, to pause everything while the immunity question was resolved at the highest level. The Supreme Court agreed to take the case, which bought Trump's team significant time as the court deliberated. And then the Supreme Court issued its ruling in Trump versus United States, which was more complicated and more nuanced than either side wanted, and which set up the legal landscape that the January 6 case now has to navigate. That landscape is what we are going to dig into now. Because understanding the difference between what the D.C. Circuit said and what the Supreme Court eventually said, and what the combination of those two rulings actually means for Trump's criminal exposure, is the most important legal question in American politics right now. Let me go deeper into the full immunity fight, because the story does not end with the D.C. Circuit ruling, and understanding the complete arc of this legal battle is essential to understanding where things actually stand. The D.C. Circuit said Trump has no immunity. Trump appealed to the Supreme Court. The Supreme Court took the case and issued a ruling of its own, and the result was more complicated than a simple yes or no on immunity. That complexity, the specific way the Supreme Court's ruling differs from the D.C. Circuit's ruling, is what determines how the January 6 case moves forward and what Trump's actual legal exposure looks like going forward. So let us walk through it carefully, because this is the heart of the legal story, and it deserves a clear and honest explanation. Start with why the immunity argument was so strategically important to Trump's legal team in the first place. The January 6th case brought by special counsel Jack Smith rested on allegations that Trump participated in a conspiracy to obstruct the certification of the 2020 election results and to defraud the United States by spreading false claims of election fraud to pressure officials to act illegally. Those are serious federal charges, and the evidence supporting them, including the Eastman tape, the Meadows grand jury testimony, the text message records, the Georgia phone call, was substantial and specific. Trump's legal team knew that if the case went to trial on the merits, if a jury got to hear all of that evidence, the outcome was genuinely uncertain and potentially very bad for Trump. So their strategic objective was to never let it get to trial, to find a legal argument that would dispose of the case before a single juror was seated. The immunity argument was their best shot at doing exactly that. If a former president has absolute immunity from prosecution for actions taken while in office, the case goes away entirely. No trial, no jury, no verdict, just dismissed. That was the goal, and the D.C. Circuit unanimously said no. Now, here is where the Supreme Court's ruling comes in, and why it is more complicated than either a complete win or a complete loss for Trump. The Supreme Court in Trump versus United States did not endorse the D.C. Circuit's flat rejection of all presidential immunity. Instead, the court established a more nuanced framework. It said that former presidents have absolute immunity from prosecution for their core constitutional powers, things like issuing pardons, commanding the military, conducting foreign policy through established channels. For those categories of official acts, the court said no prosecution is possible. But the court also said that for unofficial acts, things a president does as a candidate or as a private citizen rather than as the president exercising official powers, there is no immunity at all. And for the gray area in between, official acts that are not core constitutional powers, the court said there is a presumption of immunity that prosecutors can overcome if they can show the prosecution would not unduly intrude on executive power. That framework, official versus unofficial, is now the legal terrain that Judge Tanya Chutkan has to navigate as she decides which of the specific acts charged against Trump in the January 6th case fall into which category. And here is the critical point that Trump's team wants people to miss. The Supreme Court's ruling did not make the case go away. It sent it back to Judge Chutkan with instructions to sort out which acts are covered by immunity and which are not. That sorting process is ongoing. And what prosecutors are arguing, and what legal analysts broadly agree is a strong argument, is that many of the most important acts charged against Trump in the January 6th case are not official presidential acts at all. Pressuring state officials to submit false electoral slates, running a coordinated campaign to spread false fraud claims, working with outside lawyers and political operatives to develop schemes to reject the legitimate electoral count. Those are not exercises of core constitutional presidential power. They are not things a president does in his official capacity as commander-in-chief or chief executive. They are things a candidate does or things a private citizen does. And under the Supreme Court's own framework, they do not get immunity protection. So the D.C. Circuit's ruling that Trump is citizen Trump subject to criminal accountability was not overturned by the Supreme Court. It was refined and complicated, but the core principle survived. The presidency does not put you above the law, and a significant portion of what Trump is charged with doing is not protected, even under the Supreme Court's more generous immunity framework. Now let me connect this immunity fight to the broader pattern of courts refusing to let Trump operate above the law, because this is where the story becomes most significant for understanding the overall legal and political landscape. The D.C. Circuit immunity ruling, the Supreme Court's confirmation that unofficial acts get no protection, the tariff ruling striking down his emergency powers claims, the New York fraud judgment establishing he inflated his net worth for years, the hush money conviction on 34 counts. These are not isolated legal events happening in different contexts. They are a pattern of courts at every level saying the same basic thing in different legal contexts. The rules apply. The Constitution has limits. Presidential power has boundaries. And when those boundaries are crossed, courts are going to say so in writing on the record, regardless of who appointed the judges doing the writing. That pattern is what Trump's legal team is actually fighting against. Not any single ruling, but the cumulative judicial message that the presidency is not a shield against accountability for conduct that violates the law. And here is what that pattern means politically, because the legal story and the political story are inseparable at this point. Every court ruling that says Trump is subject to the law, every ruling that rejects his claim to operate above it, adds to a public record that prosecutors, congressional investigators, and Democratic campaign strategists can point to. The D.C. Circuit ruling gave them the Citizen Trump line, one of the most quotable and powerful formulations in the entire legal saga. The Supreme Court confirmed that unofficial acts get no protection, which means the most politically damaging allegations against Trump, the ones involving direct efforts to manipulate election results, are still potentially triable. The tariff ruling added to the picture of a president who keeps trying to claim powers he does not have and keeps getting told by courts that he went too far. Taken together, these rulings are building a legal and historical record that defines Trump's presidency in terms of consistent overreach, consistent rejection by courts, and consistent failure to establish the king-like immunity from accountability he has been demanding. That record, whatever happens in any individual case, is permanent. It does not go away when the news cycle moves on. It sits in the law books, in the court records, in the congressional files, available to be cited and built upon for as long as the legal and political battles around Trump continue. Let me break this down into 4 clear points that give you the complete and honest picture of what the immunity rulings mean, what they established, what they left open, and why they matter for everything that is happening right now. The D.C. Circuit Citizen Trump ruling is one of the most significant judicial statements in modern American legal history, and its core holdings survived the Supreme Court appeal. 3 judges unanimously wrote in clear and direct language that a former president does not have absolute immunity from criminal prosecution for efforts to overturn an election. They rejected every basis Trump claimed for immunity. They warned that his theory would collapse the separation of powers. And they used language, Citizen Trump, that encapsulated the constitutional principle at stake more powerfully than any law review article ever could. The Supreme Court later added nuance, distinguishing between official and unofficial acts, but it did not reverse the core holding. It did not say Trump possessed blanket immunity. It said immunity depends on the nature of the act and sent the case back to be sorted out on that basis. The Citizen Trump principle, that former presidents are subject to criminal law, is now established federal law that is not going away. The Supreme Court's official versus unofficial act framework is actually more favorable to prosecution than Trump's team wanted. Here is why. The court's ruling protects core constitutional acts like pardons, military command, and established foreign policy channels. But the specific acts most central to the January 6th prosecution, pressuring state officials, working with outside political operatives on false elector schemes, spreading false fraud claims to obstruct certification, those are not core constitutional acts. They are not things the president does in his official executive capacity. They are things a candidate does to stay in power. And under the Supreme Court's own framework, candidate acts and private political acts do not get immunity protection. That means Judge Chutkan, working through the sorting process the Supreme Court mandated, is likely to conclude that a significant portion of what Trump is charged with doing is fair game for prosecution. The immunity ruling the Supreme Court issued is not the blanket protection Trump was asking for. It is a framework that leaves most of the most damaging conduct exposed. The immunity fight reveals the fundamental strategic vulnerability at the center of Trump's entire legal defense. And that vulnerability does not disappear when individual cases get delayed or dismissed. Trump's legal team has consistently pursued delay as the primary strategy, not winning on the merits, delay, get to appeals, get stays, buy time, run out the clock. The immunity argument was the most powerful delay tool they had because it generated nearly 2 years of appellate litigation before a single witness was called at trial. But delay is not the same as winning. The evidence does not expire while the appeals are pending. The witnesses do not forget. The documents do not disappear. The tapes do not erase themselves. And every delay strategy that eventually fails, like the immunity argument eventually failed at the Supreme Court level, leaves Trump in the same legal position he was trying to avoid, subject to prosecution with all the evidence still intact. The freakout when the D.C. Circuit ruled was genuine because Trump's team understood that losing the immunity argument meant the delay strategy had a time limit, and that time limit is still running. The pattern of courts rejecting Trump's above-the-law claims is building a legal and historical record that matters enormously for the midterms and beyond, regardless of what happens in any individual case. The D.C. Circuit immunity ruling. The Supreme Court confirmation that unofficial acts get no protection. The tariff ruling striking down emergency power overreach. The fraud judgment. The hush money conviction. Each of these is a court at some level saying the same basic thing. You are not above the law. The rules apply to you. The Constitution has limits, and you exceeded them. That accumulated record in the official legal documents of the United States is permanent. It defines this presidency in the legal history books as one of consistent overreach and consistent judicial rejection. And for Democratic candidates running for office, for oversight investigators, for anyone making the case that Trump's conduct represents a pattern of lawlessness rather than isolated mistakes, that record is the most powerful tool available. Because it is not partisan opinion, it is what courts said in writing on the record, with judges appointed by presidents of both parties joining the conclusions. Here is the bottom line. A unanimous 3-judge panel on the D.C. Circuit Court of Appeals ruled that Donald Trump is Citizen Trump, subject to criminal prosecution with no special immunity beyond what any other defendant has, and that his claim of unbounded presidential authority to commit crimes would collapse the separation of powers. Trump's legal team appealed, and the Supreme Court issued a more nuanced ruling distinguishing official from unofficial acts, but confirmed that unofficial acts get no immunity, leaving most of the January 6 prosecution's core allegations exposed and subject to trial. The immunity argument, which was the central pillar of Trump's entire legal defense strategy, did not survive contact with the federal courts. What survived is the principle that the president is not a king, that the office does not put its occupant above the criminal law, and that when a former president tries to overturn an election, the courts are willing to say clearly and on the record that such conduct is subject to criminal accountability. That principle is now established law, and it is the foundation that every future investigation, prosecution, and accountability effort will build on.